Abja Emokwabado Badila Television. Breaking news Ichegwe said Chief Justice Onye Chief Justice Be. Na Onye Chief Justice Be ma why na Onye Chief Justice Be renting on the issue necessary. Why and next na almost a powerful bony and as I say we appointment and as on or acting as a what as a Chief Justice on a point as a appointing as a Chief Justice automatically. Na Nina say Opeja said Domelovo, yes. Ya appointed investigation body be a Domelovo account. Yes, Domelovo. Mahama appointing the on joining for the 5 members committee. Now probi a year man tokono go breaking news way and they said the next to succeed him is Justice Born. They said Mahama nipa oba succeed a year tokono and a year bafu boni. God bless you.
Very interesting decisions over the period. Some of the decisions that affect years in terms of the legal dispensation.
Right.
One that really comes to mind is the case of the ex-party's Senate case, the Republic versus the former Senate boss, the Director General, who was being prosecuted for the OBS software system. In that judgment, he discusses extensively issues surrounding administrative justice, judicial review. If you're asking a court to take a second look at the decision of an administrative body, what standards do you have to meet? It's one decision that, interestingly, the Chief Justice, who has been suspended, wrote the lead opinion. Justice Gabriel Pomai, who was on the panel as well, wrote the concurring opinion, and he discusses extensively judicial review in the Ghanaian context and how he thinks is different from the common law provision. Justice Samuel Kwame Adibu is also another senior Supreme Court judge as well. He was appointed to the Supreme Court by President Akufo-Addo. When he was at the Court for Appeal, he was also sitting as an additional High Court judge, and he was handling the trial involving the former NPP NDC chairman Samuel Ofosu-Ampofo. He was the one handling that case before we know that case was terminated eventually by the Attorney General. So that was also one matter that he did. Interestingly, and it's one of the questions that I'll be putting to counsel when we get back to him. Justice Samuel Kwame Adibu is on the panel hearing the injunction case in the Vincent as a matter. The injunction against the process. He's participating in that particular proceedings. In terms of his judgments, he also has given some very interesting judgments at the court. One of them has to do with the issue surrounding if a law is repealed and you are being prosecuted, what happens? Can the trial go on or not? For those who are familiar with the law, Edmonado versus Attorney General is the case that he wrote the lead opinion on. Very interesting decision in there. So he's a very senior Supreme Court judge at the Supreme Court who is also participating in this one. I'll end with Daniel Domelovo, the former Auditor General. You know him, most recently he was part of the Operation Recover All Loot team, a team that counsel on the line was also a member of that particular team. We know that he was Auditor General. He was one of the individuals who was appointed just before John Mahama exited office in his first term, together with the Shrad boss Joseph Hotel. When he was appointed, we know that in the course of his work, he was asked to proceed on leave, and effectively by the time he came back, in fact, he never came back. He eventually ended up retiring.
Yeah. Someone else had
the matter ended up at the Supreme Court in the case of the CD Mass and Anti-Corruption Crusader quite closely, and counsel made reference to an aspect of this particular matter that has come up. The screenshot that we see in the public domain, we don't know whether it's in the petition or not.
Having to do with audit-related matters.
Audit-related matters. And so that is another thing that has come up.
Perhaps why there could be a decision to lean in on him when there are audit-related matters in these alleged screenshots that we've seen, none of which we can substantiate.
Yes. But it's consistent with the constitutional provision in that the majority for this particular committee relative to the Chief Justice, they are not supposed to be lawyers or members of Parliament. They are not supposed to form. If you compare to the other justices of the Superior Court, the 3 are from the legal fraternity. So this time around is the 3 from the other individuals. Right. And the question first I want to put to counsel, and you did indicate that we want to make things very simple for the ordinary Ghanaian. They'll ask, who is the Chief Justice of Ghana as we speak? The statement is silent on that, but we know that in terms of the convention, if the Chief Justice is not around, the senior most judge acts in his stead. In this case, Justice Paul Bafo-Boni. Is it your understanding that with the statement being silent on that, he, as of now, should be the acting Chief Justice?
Absolutely, Akable. Absolutely. There's a specific provision for it in the Constitution. It's in there. I don't really have it here, but it's patently written that in the absence of the Chief Justice, the most senior Justice of the Supreme Court takes over. So it means that effectively, Justice Paul Bafuboni is acting Chief Justice. There can be no two ways about that.
I mean, the second question to you, Counsel, has to do with the case that is ongoing in court. Justice Kwame Adibu-Esiedu, who is on that particular panel, the injunction aspect of it, he is to form a part of this particular committee. I mean, if you were a party in the case, would you be comfortable with him remaining on the panel, or you think that ordinarily there should be some steps, maybe he himself recusing himself from it, given that they are being asked to determine first whether the person should have been restrained? That's now you've made a point that it's moot. Then the substantive issues of whether a fair hearing should be given before the prima facie determination is taking place. He's participating in that particular case.
Okay, so looking at it, it's possible maybe my answer will change. But for now, on the face of it, what we usually use to determine is whether he sat on the case. Yes, so you can be empaneled. But if you haven't had the opportunity to attend the hearing, generally, in our Ghanaian context, people will not raise our eyebrows. But from what you are saying, I get you. But, sometimes this is Ghana, it's the state of our thinking. You see, in every society, it's not everything we're able to copy exactly from the white man. Ours, because everybody knows somebody, and you will find that even in Supreme Court decisions, you see the Salah case, etc.
Right.
When it comes to recusal, we are a bit different. So the main thing the average lawyer will tell you is that he didn't sit on the case. He didn't come into open court and the case called and he had arguments. You see, but It doesn't mean that you don't have a point.
Counsel, hold on for us briefly. We've been joined by the Minister for Government Communications, Felix Kwatso-Fosu, on the telephone lines right now. He authored that statement, which has become the subject of conversation. Many thanks for joining us this afternoon. How soon did the President, in consultation with the Council of State, reach this determination that a prima facie case can or has been found against the Chief Justice? Hello, Mr. Kwatso-Fosu, can you hear us? Hello, Felix. Well, it does appear we don't have him. But Counsel was making the point about the recusals and how not so frequent of a development it is in this part of the country.
In fact, generally, the conversation centers around issues of suspicion of bias and the real likelihood of bias, which was the point he was making, that Ghana generally we tilt towards the real likelihood of bias, and the courts have over the period. In fact, we saw it happen in some of the cases. The most recent one had to do with the case relative to the declaration of some seats in Parliament as vacant.
Right.
When the matter went to court, you know that lawyers for the Speaker of Parliament did raise issues about two of the judges that they wanted recused. I mean, the court quickly went on recess, came back and took the view that once the judges have been appropriately appointed in accordance with the Constitution, it is presumed that they can act in a fair manner.
Right. Let's go back on the telephone lines with Felix Kwatso-Fosu. Mr. Kwatso-Fosu, many thanks for speaking to us. Curious on the minds of a lot of Ghanaians, when the President, in consultation with the Council of State, reached this decision that the Chief Justice had a case to answer based on these three petitions.
Please speak up. I can barely hear you.
I'm asking when between Thursday and today, when the President, in consultation with the Council of State, reached the conclusion that indeed the Chief Justice had a case to answer?
Well, I'm not able to disclose details of the process. As you yourself may know, there are strict rules of confidentiality. But I can tell you that such a conclusion has been reached, and it is on the basis of that the President has taken the step that I have just announced.
And so, amongst many other things, one question that's been asked is, this statement you issued is silent on who takes over now that the President has suspended the Chief Justice. What's the expectation of the President?
Well, the judiciary is a well-established institution in our country. They have their own administrative processes for getting someone to act in the stead of the Chief Justice in the event that she is temporarily unavailable. That is not a matter that the President determines. It is for the judiciary to make their own arrangements.
First ever of such a decision we've seen happen under any republic outside of the first ever president the country had when he removed the Chief Justice. What sort of processes went through this arrival at this decision? Because many are curious as to why we're seeing this happen for the first time and under John Mahama.
Well, the processes are clearly outlined in Article 146 of the 1992 Constitution. Indeed, you only have to read the statement I put out to appreciate the steps that have been taken. You recall that some weeks back, I informed the nation on behalf of the president that he has received petitions from 3 different courts alleging various forms of wrongdoing against the Chief Justice and demanding her removal from office. Upon receipt of that, and in strict conformity with the dictates of the Constitution, President Mahama began a consultation process with the Council of State, which consultation process required that he, in consultation with the Council of State, determine whether there was any basis to proceed, i.e., determine whether there was prima facie warranting any further steps as prescribed by the Constitution. So you recall that he forwarded the petition to the Chief Justice in consultation with the Council of State and provide responses in order to enable an assessment as to whether or not some prima facie exists on the face of the petition. This was complied with by the Chief Justice, and the President continued the consultation process with the Council of State. And the outcome of that consultation was that prima facie has been determined in respect of all 3 petitions. This also then means that Article 146 of the Constitution must kick in, which then requires the President, in consultation once again with the Council of State, to set up a 5-member committee whose composition is contained in the statement I just issued. That membership of the committee is such that 2 of the members must be justices of the Supreme Court,
right?
One of whom will chair the committee, and 3 other individuals who are neither lawyers nor members of the Council of State. And so you find that the 3 others who have been named meet this criteria. They are not lawyers, they are also not members of the Council of State. Once that is done, the petitions will then have to be referred to the committee to inquire into as to whether or not there is a basis to remove the Chief Justice from office. Now, while the committee does its work and once it has been set up, Article 146(10) of the Constitution empowers the President to suspend the Chief Justice for the duration of the work of the committee up until such time that they make recommendations to the President on what further step to take. So you find that everything the President has done has been grounded in the Constitution, Article 146, and its various provisions. So if you ask me about the process, this is exactly what has transpired since the tendency of these petitions.
All well and good, these processes you've outlined, but one criticism which is coming strongly from the quarters of the opposition NPP is that you're abusing these laid down processes in Article 146, and what we've seen happen up until this point is an attack on the country's judiciary.
Well, first of all, the NPP itself has come in for criticism for their unwarranted politicization of this particular issue. It is curious that it is a political party, the New Patriotic Party, that appear to be up in arms about this. Otherwise, every reasonable person understands exactly what is happening. That the President is required to act in specific ways once he receives this petition. In fact, before President Mahama took office, in the dying embers of the Akufo-Addo administration, a similar petition went to the President, and he took the same steps that the President has taken, except, of course, the determination of a prima facie. President Akufo-Addo also the Constitution. So one has to question the sincerity that they bring to this whole discourse and question whether or not it is not politically motivated. Because quite frankly, they have not covered themselves in glory in this particular matter. They have needlessly politicized this and created an impression that the Chief Justice is one of them and she's been handed. And it is manifestly unfair to the Chief Justice what the MPP is doing Their claims also do not hold merit because they cannot point to a single infraction on the part of the president in this whole process. And I'm not sure why they continue on the tangent that they are going. What has simply happened, and I must stress that the president has not said that the Chief Justice is guilty of any offense. The president has only said that when he consulted with the Council of State and looked into the petitions and weighed them against the Chief Justice's responses, it became clear that there are further questions that need some answers. The platform to do that is spelled out clearly by the Constitution, and the president has followed that particular stipulation to ensure that the matter is determined conclusively, but it is determined by persons who are clothed with the mandate to do so, which is the committee that he has set up. So, again, I must express my surprise about the conduct of the new presidential party in this instance. One can only infer political motives to what they are doing.
Just final question from me in relation to this 5 members we're seeing, senior most, second most, senior most at the Supreme Court, and then the membership. We see a security person, we see an auditor, a former auditor general as well, and then a person from academia. Is this leaning into the details captured in these petitions, which is forcing the president to toe the line in the individuals, the non-members from the Supreme Court, which we're seeing on this 5-member committee?
Well, the rules governing this process are pretty strict and stringent. One is not permitted to make any disclosures in respect of the details of the petitions. It is only the president, the Council of States, the petitioners themselves, the Chief Justice, who natural justice demands is giving copies of the petitions, and the committee that has been set up who are seized with the petitions. No one else has a right or authority the details of this petition. So, regrettably, I'm unable to answer your question as to whether or not it is the nature of the petition that has necessitated the selection of the individuals who have been selected. Right. That if I were to go into the mind of the president, I believe that he thinks that these are the individuals who have what it takes to unravel the facts surrounding this petition, whether or not there is even any basis to remove the Chief Justice.
Then Felix, I appreciate that you could join us this afternoon. We'll leave the conversation. I'm sure we'll come back to you as and when it does require. So that's Felix.
In this case, it is mandatory, all right? It is mandatory. The president would have no discretion in the matter, meaning that if the committee says the Chief Justice is not liable, or in other words, not guilty, the president is bound to go by it. Vice versa. If they were to say she's liable or let's say guilty, the president must go by it and so remove her. Okay, so and you know in 2015 we had an example, Vivian Loretta Lamptey. You remember the Shraj boss? Yes, she was taken through the same process. You remember an MPP member, Frank Anodompre, petition for a removal. It wasn't that petition that was, was used, but the one by Richard Nyama, also affiliated to the MPP, right? Yet the process went on. The Justice Benning Committee went into it, and when they came out, their verdict was that she be removed because the grounds for her removal had been established. So President Mahama had no option but to remove Loretta Vivian Lamptey. So that's what happened. So similarly, in this case, the recommendations of the the committee is what the president would go by. Yes, because you see that it's a committee that's going to go into the matter. They are the people going to hear the evidence on oath. As I've said, for now, let's leave out the fact that people can lie on oath, etc. The oath is no longer as solemn as it used to be in those days, but still, it's the oath. So they are going to hear these matters on oath, and they are even going to hear cross-examination. You see, sometimes you see something like A. But when the cross-examination comes in, that's when you see different shades of gray. So it's because it's a committee that will be seized with all of this, hearing all the evidence, etc. You see that at the end of it, they will be in a better position than the president to make a recommendation as to what should happen. So the Constitution has given them the greater weight that their recommendations are what the president should go with.
And Council, I want to end with 14611 because that provision states that the president may at any time revoke a suspension under this article. So it means that in between now and when the committee is having its proceedings, the Chief Justice could potentially be back in office if the president decides to do so. You agree with that as well?
Yes, theoretically, sure. Theoretically, it's correct. But let's also watch the practical side. You see, suspension of a Chief Justice is not a light matter. And you know me, we've been making noise all these years that in the new Constitution, the president should not be the one to appoint Supreme Court justices. And for that matter, all Superior Court justices, etc. One separation of powers, a better form of separation of powers, etc. So I know that the president did not take this decision lightly. So such a decision is not the type that you easily find it being reversed. No, because the integrity of the whole process, to be honest, practically, it's not something that will be lightly done.
We'll leave it here for now, Council, and we'll come back subsequently as and when there are more developments with regards to this particular story. And so that is Martin Kpebu. He's a legal practitioner, rights advocate. We've been engaging on this particular breaking news that is just coming in. And if you are just joining, the breaking news is that the president has suspended the Chief Justice. As you may be aware, there are 3 petitions seeking her removal from office. And the very latest on it is that the president has come to the conclusion in consultation with the